This company thinks I owe them $10,000 in damages a day, assuming that I'm reading what's in this legal paperwork here that they sent me correctly. And I'm not a lawyer, so it's possible that I'm not interpreting this properly, but I'll let this be up to you. There's a company called Cami Research, and they make test equipment. They're based in Massachusetts. And a fan of the channel, great viewer, Stephen Ryan, bought some of this equipment on eBay. There were some issues he had with the equipment, so he reached out to the company, open to buying schematics, tools, diagrams, parts, anything that would help him to be able to fix this equipment. He had no problem with the equipment. However, the company did not want to help him. And they said the quiet part out loud while they were talking to him, and he published it on his blog in an article regarding them and right to repair, which I covered in my video. News, Cami Research and right to repair, anti-repair. They said what is, in my opinion, the quiet part out loud, which is that if you are able to fix the old products and people fix the old products, that may be taking business away from them, and he doesn't like that. But don't take it from me. Listen to his own words.
Buying these things off the market, and you could be buying these things off the market and selling them and making a profit at it, and that's taking business away from us, and I don't like that idea either. So I think I'm going to hold off on this at the moment, and if you want to send me some data.
Yeah, I was just being polite and courteous here, trying to extend a conversation on the right to repair here, hoping that you would see what's required.
I have a lot of respect for Mr. Stephen Ryan. Stephen Ryan has showed up at multiple right to repair hearings. He is one of the primary people that is the reason that Washington got a right to repair bill passed without all the nonsensical exemptions that exist in many other states. He puts a lot of time into this, and he doesn't just talk about it, he lives his ethics. On his channel, he helps show people how to repair. In his own life, he helps get people involved in repair. And above all, he has an adorable cat. If you don't like the adorable cat, I really don't know how to sell you on Mr. Stephen Ryan at that point. I haven't met him personally, but I don't have to meet him personally to have a lot of respect for what he does, what he stands for, and the amount of effort that he's put in to push right to repair forward. He wanted to buy this product. He bought a product on eBay that came with a couple of problems, and he wanted to go to the company to give them money to have a collaborative relationship so that he could fix that product and use it in his business. And he said the quiet part out loud, which is, if people are fixing the old products that are out there, maybe they're not going to buy new ones from us. That is, in my opinion, a cartoon villain level to stoop to. And listen, if a company wants to stoop to that level, you do you. So I did a video covering this entire thing, and I gave my opinion on it. And my opinion was quite, it was what you expect of a company that acts this way, as somebody who has fought for right to repair for the last 12 years and been involved in the industry for 16. I don't like the fact that most companies try to stop you from being able to repair what you bought and paid for because they're afraid that it'll cannibalize sales of new products. I don't like living in a throwaway society. And I went over what I thought in that video. A few months after I did the video, I get this letter from Baker, Sterchi, Cowden, and Rice. It's dated September 5th via email and U.S. mail. Cease and desist. Mr. Rossman, our firm has been retained by Cami Research, Inc., hereafter referred to as Cami Research. If you are represented by an attorney, please immediately forward this letter to them and have them contact our office. By way of background, Mr. Sterchi is president and founder of Cami Research, a company that manufactures Cable Eye, an automation-ready cable harness test system. Mr. Stephen Ryan purchased a used Cable Eye tester from eBay last year and later requested firmware updates for that product. Mr. Ryan had begun requesting schematics, diagrams, and other proprietary information, citing the Washington and Oregon right to repair legislation. When Mr. Sterchi rightfully declined these requests, Mr. Ryan initiated complaints with the California, Oregon, Minnesota, and Washington Attorney General offices, as well as the Department of Justice for the state of Oregon. The complaints filed in the state of Oregon were closed without any action taken. The remaining offices have not responded or taken action with regard to the allegations. Under RCW Section 19-415-0104C and Oregon Senate Bill 1596, which became effective on January 1st, 2025, equipment manufacturers are required to provide documentation regarding the maintenance and repair of consumer electronic products, which are generally used for personal, family, or household purposes. Neither law applies to products or equipment that have never been available for retail sale to customers. RCW Section 19-415-0408C, SB 1596, Section 13GB, 82nd Legislative... Okay, just for the... Can you guys do me a favor since I'm putting this on the screen, and just forgive me if I don't read all the letters and numbers and mumbo-jumbo there when I'm going through this. It's 11 o'clock at night here, so excuse me on that one. If you're interested in that, it's going to be on the screen. Neither law applies to products or equipment that have never been available for retail sale to customers. Additionally, enforcement of Section 1 in Senate Bill 1596 does not begin until July 1st, 2027 at Section 7. Cami Research does not manufacture any consumer electronic products as defined under statute, nor does it sell products directly to individual consumers. The requirements set out by these laws are therefore inapplicable to Cami Research and its manufactured products. Cami Research is not legally bound by these provisions and is not required to provide the requested documents. On December 10th and December 12th, 2024, after Mr. Sterchi declined initial requests for proprietary information, Mr. Ryan contacted Mr. Sterchi via telephone and recorded the conversation without his consent. them. Mr. Ryan then published portions of those conversations to his website, StephenRyan.com, on June 13, 2025, in a blog post titled News, Cami Research and Right to Repair, Anti-Repair. In the state of Washington, recording private telephone communications without the recorded consent of all parties is prohibited. Any individual who violates the statute is subject to liability for damages, including actual damages, pain and suffering, attorney's fees, and litigation costs. Additionally, anyone who violates this is guilty of a gross misdemeanor. Similarly, under Massachusetts laws, it's a misdemeanor to willfully disclose the contents of any secretly recorded conversations. Massachusetts and Laws, Chapter 272, Section 99C3. In addition to criminal penalties, the publication of these conversations carries civil penalties in both jurisdictions. Under Washington law, defamation action consists of 4 elements. 1, a false statement. 2, publication. 3, fault. And 4, damages. In Massachusetts, plaintiffs are required to demonstrate that a false statement was made to a third party which caused economic loss. Mr. Ryan did not request Mr. Strangio's consent prior to recording these conversations. Mr. Ryan's publication of the conversations in the blog post is a misdemeanor under both Washington and Massachusetts law. You became involved at this point and posted a video to your YouTube channel disparaging Cami Research based in part on those unlawfully recorded phone calls and the inaccurate information being preferred by Mr. Ryan. You posted a video publicly accusing Cami Research of failing to comply with right to repair laws. Cami Research was inundated with negative Google reviews immediately after the video was posted, going from 5-star rating before the video to just 1.3 stars after. The ensuing reputational and economic damage these actions have caused to both Mr. Strangio and Cami Research continue to this day. Your libelous actions have caused Cami Research to suffer over $100,000 in actual and reputational damages, and that amount continues to increase. Accordingly, this is a formal demand for you to take the following actions to mitigate further harm. Number 1, remove and retract all defamatory statements in the media alleging Cami Research failed to comply with right to repair laws. Such media includes but is not limited to your YouTube channel, social media, websites, and Cami Research's own Google profile and social media sites. Number 2, cease and desist from recording, posting, or otherwise disseminating any conversations involving Mr. Strangio or Mr. Cami Research employees. Number 3, remove and permanently delete any unlawful recordings or posts containing such recordings from all platforms on which they have been published, and from any private storage. Number 4, issue a retraction on your media channels, including but not limited to your YouTube channel, blog, and/or website, and social media platforms, indicating to your followers that right to repair laws are inapplicable to Cami Research testers because they are not consumer electronic products. This retraction should include a request for your followers to remove all false and defamatory comments on all media as defined in Action 1, especially as these followers have never purchased products from Cami Research and have no valid basis for complaint. Their fabricated comments were incited by you, and these followers may also be liable for defamation if the comments are not removed. Number 5, issue a formal apology on your YouTube channels, websites, and social media accounts to Cami Research and Mr. Strangio himself for propagating false and defamatory information about Cami Research products and services. These demands shall apply to your agents, employees, or anyone you have engaged to act on your behalf. I demand that you immediately comply with the above actions and confirm in writing your compliance with this demand letter within 5 business days of the receipt. Your letter must clearly state that you have complied with all the steps outlined above and that you will refrain from future violations. The damage to Cami Research continues each day that these comments and false information remain visible to the public. If you fail to do so, Cami Research will pursue all legal remedies, including but not limited to injunctive relief, additional monetary damages at a rate of $10,000 per day, reporting to law enforcement and all other remedies under applicable law. This letter serves as your final warning to stop the aforementioned conduct. Very truly yours, Megan M. Coluccio, Baker, Sterchi, Cowden, and Rice, LLC. I got this a few hours ago. My response. Responding to Cami Research, Inc., cease and desist. Dear Ms. Coluccio, Rossman New Media 2 is a Texas S corporation that owns and operates the YouTube channel in which Mr. Rossman publishes commentary. Rossman New Media 2, not Mr. Rossman personally, and not Rossman Repair Group, is the proper party for any communications concerning the video referenced in your letter of September 5th, 2025. Having reviewed your correspondence, Rossman New Media 2 denies any actionable claim exists. For the reasons below, your client has no viable claim, and Rossman New Media 2 declines your demands for removal, retraction, apology, or content suppression. Truth/substantial truth and disclosed fact opinion defeat any defamation theory. Your letter acknowledges that a Cami representative stated to a consumer, in substance, that repairing and reselling used units could, quote, take business away from Cami, and that Cami would hold off. And I quote from that recording, you could be buying these things off the market and selling them and making a profit off it. And that's taking business away from us. And I don't like that idea either. So I'm going to hold off on this at the moment. Rossman New Media 2's video accurately conveyed and criticized that stance. In Texas and everywhere, truth and substantial truth are complete defenses. See Dallas Morning News, Inc. versus Tatum. Substantial truth. KBMT Operating Company, LLC versus Toledo. Texas Civil Practice and Remedial Code, Section 73005, Truth Defense. Your letter emphasizes that Oregon Senate Bill 1596 and Washington statute apply only to consumer electronic products, not industrial testing equipment. The video's criticism, however, was aimed squarely at Cammie's policy choice, refusing to support repair on the ground that it could reduce sales, not as a definitive adjudication of the statutory coverage. That anti-repair stance, expressed directly by Cammie's leadership via Mr. Strangio, appears to have been the basis for the public's negative reaction. Even if Cammie's testers are ultimately classified as non-consumer goods, the criticism remains the same. The public was disturbed by Cammie's stated hostility to repair of used units, not by any fine distinction between consumer and industrial categories. Moreover, whether such equipment qualifies as consumer goods is not nearly as clear as your letter suggests. Courts applying the UCC have held that products originally purchased for commercial use can be reclassified as consumer goods once individuals acquire and use them personally. See in R.E. Tucker, 329, BR 291, Banker, Arizona, 2005. Vehicles initially acquired for business reclassified as consumer goods once used personally. In R.E. McDaniel, commercial lawnmower reclassified as consumer good when used for home lawn care. In Press versus Perks, a quarter horse treated as a consumer good when owned for personal purposes. Courts have recognized in analogous context that reclassification by use is well recognized, and at minimum makes the consumer electronic question debatable. Where scope is contestable, Mr. Rossman's statement that Cammie was violating right to repair cannot be treated as a provably false factual claim. It was an evaluative opinion grounded in disclosed facts and therefore constitutionally protected. To the extent that commentary categorized Cammie as acting contrary to right to repair, those are value judgments based on disclosed facts, not provably false assertions. Such opinions in rhetorical hyperbole are protected by the First Amendment. See Milkovich versus Lorraine Journal Company, liability only for provably false factual statements, Greenbelt Co-op, Old Dominion Branch 496, National Association of Letter Characters versus Austin, Trader as rhetorical hyperbole, New Times Inc. versus Isaacs, satire, rhetorical hyperbole, not actionable. Oregon authority is in accord. See Newman versus Lyles. Is that Neumann, like the microphone U87, or Newman? Either way, again, it's way too late for this shit. Online consumer criticism protected when based on disclosed facts. Any recording law issues do not create liability for Rossman New Media 2. Publication and commentary by a non-interceptor on a matter of public concern is protected. Rossman New Media 2 did not record, solicit, or aid any recording. Rossman New Media commented on and criticized statements made available on a public website by the consumer. Even if the original recording implicated a two-party consent statute, the First Amendment prohibits imposing liability on a non-participant publisher of truthful information of public concern that the publisher lawfully received, Bartnicki versus Vopper. As you can see over here, literally the #1 result on Google for Cammie research versus right to repair, the #1 result right now. And when I did my video is his blog post. The statutes your letter cites, RCW 9.73.030.6060, Washington and Massachusetts General Laws, Chapter 272, Section 99, govern the act of interception and recording. They do not impose liability on later speakers who lawfully access and comment on information already made public. See Commonwealth versus Hyde, Massachusetts, Scope, Section 99, limited to secret recorders. Rossman New Media 2 did not record, intercept, or originate publication of the audio at issue. It obtained the material from a publicly available website and criticized Cammie's own words. Under Bartnicki versus Vopper, imposing liability on such commentary is constitutionally barred. The right to repair point is protected commentary. Statutory scope is at minimum debatable. Rossman New Media's video criticized Cammie's policy choice, refusing repair assistance because it might reduce new sales and express lay opinions about right to repair principles based on disclosed facts. See Milkovich, 497 U.S. at 18-20, Tatum, 550. Again, it's close to midnight. We're not doing that right now. We do not concede statutory coverage here. We note only that Oregon Senate Bill 1596 became effective January 1st, 2025, with the Oregon Attorney General's Civil Penalty Enforcement Authority operative July 1st, 2027. Or SB 1596, 2024, Section 7, Washington's 2024 law covers consumer electronic products and excludes products never available for retail sale to a consumer. RCW 19415. 0408C. Whether Cammie's testers ultimately fall inside or outside these definitions is at minimum debatable, and certainly not clear enough to render Mr. Rossman's commentary defamatory. Public concern speech shifts burdens Cammie cannot carry: falsity, fault, and actual injury. This dispute concerns consumer repair access and manufacturer policy, which are matters of public concern. A private figure plaintiff therefore bears the burden to prove falsity and fault. Filing Newspapers Incorporated versus Heps. Recovery for a private plaintiff is limited to actual injury absent proof of actual malice. Gertz versus Robert Welch. Cammie identifies no provable false factual statement by Rossman New Media 2, and it cannot show actual non-speculative damages proximately caused by Rossman New Media 2's protected commentary. See Bentley versus Button. Competent evidence of actual damage is required. Rossman New Media 2 did not instruct anyone to post false reviews and does not control third-party platforms. Lawful critical reaction by the public to Cammie's own statements is not a basis to punish Rossman New Media 2's protected speech. Personal jurisdiction and venue outside Texas are improper. Rossman New Media 2 and Mr. Rossman are in Texas, if you didn't notice by my accent. The video was created and uploaded in Texas to a nationwide audience. The plaintiff's location cannot supply jurisdiction. The defendant must have purposely directed suit and conduct at the forum, Walden versus Fior. Publishing content on the internet without forum targeting is insufficient. See Revel versus Ladov. Any suit outside of Texas invites dismissal or transfer. Anti-SLAPP, early dismissal and mandatory fee shifting. Texas, TCPA. In Texas State Court, Rossman New Media will move under the TCPA, Texas Citizens Participation Act, which mandates early dismissal where the plaintiff cannot establish a prima facie case by clear and specific evidence, and provides mandatory attorney's fees and sanctions to a prevailing movement. Washington, UPEPA, RCW, Chapter 4, 105, provides an automatic stay, early merits review, immediate appeal, and mandatory fee shifting to a prevailing movement. Oregon stays discovery and mandates an award of reasonable attorney's fees and costs to prevailing movement. Massachusetts, GLC 231, Section 59H authorizes a special motion to dismiss with fee shifting for petitioning activity. Here are some real fee exposure examples. Texas courts have awarded 5- and 6-figure fee and sanction awards after SLAPP dismissals. See Landry's Incorporated versus Animal Legal Defense Fund. Sanctions remitted to $250,000. Additional fee awards of over $82,000 and $30,000 on remand. Comparable mandatory fee awards are routine under Washington's UPEPA and Oregon's anti-SLAPP. Prior restraints and compelled speech are constitutionally disfavored. Pre-adjudication injunctions against speech are classic prior restraints and presumably invalid. Org for a Better Austin versus Keefe. Texas permits only post-adjudication takedown relief limited to statements actually adjudicated defamatory. Kinney versus Barnes. Your demands for compelled retraction or apology are improper. Rossman New Media 2 declines them. Rossman New Media 2's position and requested preservation. Rossman New Media 2 stands by its accurate reporting and protected opinions. It will continue to speak lawfully on matters of public concern without waiving any rights. Rossman New Media 2 requests that CAMI preserve all documents, communications, and policies concerning provision or refusal of parts, documentation, and repair assistance, communications with the consumer referenced above, and any internal and public relations discussions concerning this dispute. This matter presents truthful recording and protected opinion on a public issue. No unlawful recording by Rossman New Media 2, serious jurisdictional obstacles outside of Texas, and powerful anti-SLAPP remedies with mandatory fee shifting. Litigation would be legally unsustainable, economically inefficient, and reputationally counterproductive. We urge CAMI to reconsider and to focus its efforts on constructive engagement with its customers in the community. Should CAMI nonetheless file suit, Rossman New Media 2 will promptly seek dismissal and full recovery of fees, and where available, sanctions. Respectfully, and all the citations. That's the legal letter response. Let's get to my response. Let's just put aside the idea of this bill applying to professional stuff versus test equipment versus consumer electronics. Put that aside for a moment. People are not mad because you disobeyed the law, and if the law did not apply to professional equipment, everybody's just hunky-dory with your statement. People are angry that this law has to exist at all. They've been angry at this for the last decade. The fact that there are even people out there that justify a law like this ever having to be presented because people think that it is bad if customers are able to fix what they own. If I can fix my MSI laptop, that means that I'm less likely to do business with MSI, and that's a problem for MSI. People are not angry at you because I have some sort of issue with the distinction between a consumer product and a professional one. They're angry that the law has to exist at all. And this law is proposed because of people who make statements like the CEO or owner of this company. I don't feel weird. I don't feel inadequate if people buy my products that I sell and then fix them themselves and something goes wrong with them. I sell hot air rework stations. We fix things at my store, but we also provide products that we sell on store.rossmangroup.com, or it used to be before the tariff mess. When you bought this product, we offered a 2-year warranty with it. If it goes wrong a little bit outside the 2 years, we'll still help you for free. And if you're very long outside the warranty period and something goes wrong with it, I'm not just going to say, well, I have a problem with you fixing it because that could be cannibalizing sales of new products for me. Because there's tons of different ways that I can make money. My value to the world is not based on me putting a gun to your head and telling you that you only have one way to service your product, and that's through me. I want you to have as many choices as possible. It's why I make all the repair information that I do available on this channel for free. I want people to not feel like they have no choice. I want you doing business with me because you think that's the best possible option for you, not because you feel like you're coerced or forced or had your arm twisted into it. And that's worked out pretty well for me over the past 16 years. And here, the reason that people are annoyed, again, that's the thing that gets me, is the tone deafness of it. The fact that you believe that what people are actually aggravated at is the distinction between professional and consumer equipment. It has nothing to do with it. It's to do with everything to do with your stance, that every single time somebody fixes something, when they make something work again, when the fan spins, that's business that's been taken away from you. And you see that as a problem. And the thing that bothers me the most about this is there are actually people in my comment section that thought that your business model is a fine model. They think I'm a jerk. It's the very minority opinion, but they think that. But none of them is saying this video has to be taken down. If you want to have this opinion, if you want to believe that every single time something is fixed, that is a problem because it's potentially cannibalizing a sale of your product or service, have that belief, but own it. Don't back down from the statements you're making to people that bought your products. Own it. I've said controversial things on my channel. I've said controversial things on Reddit. There's tons of reviews on my business listing that have absolutely nothing to do with the customer experience, simply because my name, Louis Rossman, is associated with the Rossman brand, which is associated with things that I say on YouTube and on Reddit and on other forums. I don't ask Spectrum to find me, bring me their IP address so I can fucking sue them, ask for $10,000 a day for No, I don't. I respond. And that's that. If you think my opinion is so wrong and I'm a horrible person, then come on and make a video explaining how your company does business. Don't try to get my stuff taken down. You think you can bill me $10,000 a day and then tell me that I have to apologize to you and go, I'm sorry, sir. I'm sorry that I read back your own words to the audience of people that may buy your products. I'm so sorry for letting the world know exactly what you think of your customers. I'm so sorry. Who do you think I am? One of your customers? Somebody that you're used to being able to get away with this shit with? No. 10 years ago, Apple asked that I take my videos down, and they went through a law firm that's much more expensive than the one that you went to, Kilpatrick and Townsend. They asked that I take my videos down because there was a schematic page and it's showing where the fuse was located in an A1466 MacBook Air. I didn't take my videos down. As a result of not taking my videos down, I made 600 new videos on how to fix these products, including the schematics. And ever since I did that, my channel went from being the only channel on YouTube that was showing how to do this type of motherboard repair stuff with Apple schematics to one of thousands of channels showing how to do it. And thousands, tens of thousands of other people started uploading videos and had to do the exact same thing. John Deere was going anti-right to repair with tractor manufacturers. So do I sit down there and do nothing? Or do I find members of the Farm Bureau that are secretly siding with the manufacturer instead of farmers and their constituents and get bills passed in 2 states against John Deere and their anti-competitive practices? We went up against the wheelchair industry too. Google asked us to take down an application. New York State had a false lien and warrant on my company for 7 years. And spent a year and a half auditing me over something that was less than a 0.01% error rate. But I'm supposed to apologize and bow down to you, the cable testing company in Massachusetts, that doesn't like the fact that I played back your own words. Tell me more. You didn't think that this letter was going to get listened to, did you? You must be kidding me. Because my goal with this is not just to make it very clear that you have not only no legal standing or basis here, but it's also to set the precedent going forward for other YouTubers. Because what really bothers me, see, this is not about me. This, honestly, forget about me and forget about my channel. Forget about whatever legal trouble or financial issues I may get into. What bothers me is the culture. On this website, every time there's something like this, like Stephen Fisher, much tougher guy than me, much stronger than me, definitely could kick the shit out of me, black belt. I barely made it past the first 10 months of my martial arts training. He took down his video the moment that DCS came knocking. It meant that Mark didn't take down his video the moment they came knocking, but somebody else took it down for him. On this platform, every single time there's some sort of cease and desist or defamation claim or something like that, the YouTuber goes into hiding and says, I make maybe only a few thousand a month in monetization and a few more in sponsorships. I don't want to lose my channel because the big company's mad at me. I guess I'll just unlist my video. And then the community figures out that they unlisted their video, and the community rallies around the YouTuber, and the YouTuber eventually puts their video back, and then 6 to 9 months later, after everybody's forgotten about it and the video is no longer making its rounds, and there's millions of people who haven't potentially viewed it and been aware of the company's bad practices because they took it down, the video goes back up, and then the cycle repeats itself. And I'm sick and tired of that shit. The next time that somebody puts up a video that is factually correct in representing what a company has said or did, I want them to keep that video up. I want to set an example for that. I'm trying to get people to clean up their corner of the world. I'm trying to get people to change their behavior. The entire concept of the clipping movement is getting people to do the small things they can where they can. Yesterday, I did a video that could be construed as me endorsing community policing so that people don't have AI-powered surveillance cameras all over their neighborhood. I'm trying to get people to change the way they think, trying to get people inspired to try and repair things that companies have bricked and produce the solutions to them publicly. And you want me to fucking retract the video that I did that was playing back your own statement? Are you kidding me? What kind of example would that set for me? That would destroy every single thing that I ever worked for. I'm here to try and clean up my corner of the world, and hopefully, by example, inspire others to try and do the same. And when I look at my corner of the world, I see you as the dust. That's what I think of people that conduct themselves the way that you did. I see you as the dust. It isn't just about me, which is why when this video is released, the next time that a company sends out some garbage like this to a content creator that's created factually correct content, if that content creator wants to respond to it with a lawyer and they do not take their video down, condition, do not take the video down, I'll pay the first $10,000 of your legal fees right out of pocket. We got to start setting a precedent here. Clippies together, strong. Clippies by themselves, weak. I'm not going to go out there and tell people to clean up their corner of the world if I'm not even willing to sweep up a little bit of dirt in mine. It's insane. Firstly, my video stays up. Secondly, I stand by every word I said in that video and then everything I put in my letter. Number 3, the next person that gets one of these nonsensical claims, as long as you do not take down your video and you commit to fighting it, I'll pay the beginning of your legal fees. It has to start somewhere. If it doesn't, then we're just going to continue to have this culture of fear where people remove their videos from YouTube and go, I don't want the company to sue me. I'm sorry, sir. I'll never say anything about you again. Fuck that. And fuck where it came from. People are so quick to take down their videos the moment a company goes after them. Because most people are normal. They do YouTube to pay their bills. They have a family. They have a wife. They have kids. They want to go to sleep on time. They want to live normal lives. I don't. I don't care if this channel makes me money. I don't care if I hire a firm to defend myself against this and I spend every dollar that I have. I would enjoy that if it simply meant that there was a 5% chance that I set a precedent that people like you don't win. You want to be able to say these things and have these policies, but not deal with any of the societal consequences of it. I think everybody should know exactly how you do business, and they should know exactly what you said. I'm not backing down at all. And if you think I'm backing down to you after not backing down to Apple or Google or John Deere or the wheelchair industry, man, good luck with that. You picked on the wrong fucking guy. That's it for today. And as always, I hope you learned something. I'll see you in the next video. Bye now.